Good evening, ladies and gentlemen, and welcome to everyone here and to those joining us in Townsville and Rockhampton to this, the first of the 2017 Selden Society Lectures. Tonight, Justice John Bond will address us on the topic Chief Justice John Marshall and the establishment of judicial review. John Marshall holds a special place in the history of the United States Supreme Court and in the development of constitutional theory in that country. His work in that role had some part in the development of our own Commonwealth Constitution, and that can be seen at least from the 14 separate references to him in the Constitutional Convention debates of the 1890s. To consider Marshall's place, we have the benefit tonight of the research of Justice John Bond. Justice Bond's interest in constitutional matters was, no doubt, sharpened by his service as an associate to Sir Gerard Brennan in 1985. After filling that role, he worked as a solicitor for a short while until he was admitted to the bar in 1987. He took silk in 1999. During his time in practice, he served for 9 years on the Queensland Law Reform Commission and contributed substantially to its work. He was appointed to this court in 2015 and is one of the court's commercial list judges. Justice Bond.
Thank you, Justice Martin. On a low plinth in the ground floor of the Supreme Court building in Washington, DC, sits a bronze statue of John Marshall, the fourth Chief Justice. The statue was commissioned by the Bar Association and originally located in front of the Capitol building in 1884, but it moved to its current location in 1981. The statue has pride of place in the building. If you go on a tour in the building, docents will regale you with reasons why John Marshall, the longest-serving Chief Justice, at least thus far, is often regarded as the greatest. One of the first justifications for that view, which they will mention, is the case of Marbury and Madison, a decision of the court in 1803. As we all know, and as Justice Martin mentioned, in that case, Chief Justice Marshall authoritatively established that a purported exercise of legislative or executive power might be reviewed and its legality ruled upon by the judicial arm of government. Justice Marshall famously stated the propositions that will be on the screen behind me. Each of those has found its way into the reports of this country. They represent stirring stuff, admittedly. But Marshall's articulation of judicial review was not the first time that such theories had ever been propounded. Precursors included observations made in England by Cook in Dr. Bonham's case in 1610, and Cook's observations appear behind me. Then, in 1761, one of the first colonial cases in which such an argument was advanced was a case called Paxton and Gray. Apparently founded on Dr. Bonham's case, the advocate contended that writs of assistance, which had been approved by a colonial parliament to permit to permit general searches in aid of the enforcement of customs duties, were against the Constitution of Massachusetts and therefore void. Perhaps the most influential of the precursors to Marbury and Madison was to be found in the Federalist Papers. An express articulation of judicial review was presented by Alexander Hamilton in 1788 in Federalist number 78. The relevant passages appear behind me now. Federalist 78 was actually cited to the Supreme Court during the oral argument in Marbury and Madison. Note from the quote that I've put up on the screen the reference to a limited constitution, Hamilton's understanding that such a thing had certain specified exceptions to legislative authority, and that limitations of that kind could be preserved in no other way than through the medium of courts of justice. Apart from those precursors, it is, however, notable that Marshall's articulation of judicial review in 1803 was not even the first time that it was proposed by a Justice of the Supreme Court. In 1795, Supreme Court Justice William Paterson who later formed part of the court in Marbury and Madison, formulated a charge to a grand jury whilst on circuit in Pennsylvania in a case called Van Horn's Lessee and Dorrance, a case in which he found it necessary to address the grand jury on the constitutional validity of a state law. He explained to the jury the English doctrine of parliamentary sovereignty and advised them that in America the case was widely different because of the existence of written constitutions. And you've got the first part of two passages that I want to show you from that case in front of you. You'll note the wonderfully colourful language, and you'll note the implicit criticism of parliamentary sovereignty. You'll see reference where His Honour observed, some of the judges in England have had the boldness to assert that an act of Parliament made against natural equity is void. I think that's probably a reference to Cook. And then it continues with a recognition of parliamentary sovereignty, which of course had, if you'll pardon the expression, trumped Cook well and truly by then. Now, although Patterson's remarks were directed at state constitutions, there could be no doubt as to the generality of his intention. He went on to describe what the position was in a written constitution. And you see the passage in which he does that behind me now. The critical aspects of what he observed are found in the passage commencing with the words, "I take it to be a clear position." That is as explicit a statement of judicial review as is to be found in Marbury and Madison. Similarly, in the 1798 decision of Calder and Bull, which considered whether a law of the Connecticut legislature was an ex post facto law prohibited by the federal constitution, Supreme Court Justice James Iredell explicitly stated, and having just described in the earlier passage of his judgment what Blackstone parliamentary sovereignty was, principle of judicial review. And what is notable is he starts with the express criticism of the Blackstonian parliamentary sovereignty that he'd just summarised. He described it as so great an evil. And then he goes on in the last sentence, again, to summarise judicial review. If an act of the Congress or the legislature of a state violates those constitutional provisions, it is unquestionably void. Now, against that background, one might well wonder why Marbury and Madison has assumed the prominence which it has. In a recent paper that you'll find in the paper which, when it's published, Ronald Sackville has pointed out that historians in the US have questioned why this is so. Apart from the two cases I've just mentioned, Sackville notes that there was even a decision in 1796 where the Supreme Court addressed the constitutionality of a federal statute on a case stated. And although the challenge failed, there was no evident doubt that the court had jurisdiction to entertain the question. I think these criticisms are misplaced. To my mind, sufficient justification for the prominence of Marshall's judgment in Marbury and Madison is found in the status of the previous decisions and in the doctrine of precedent. Justice Patterson's jury charge in Van Horn's Lessee and Dorrance was to a circuit court grand jury. Justice Iredell's remarks in Calder and Bull were made in the course of a case which addressed a state act and which in any event found that it didn't contravene the Constitution. And in Hilton and the United States, the court answered the question posed by the case stated in favour of the conclusion of validity. On the other hand, in Marbury and Madison, that was the first time the Supreme Court determined that what was otherwise a valid legislative act of the federal government was void on the grounds that it was contrary to the Constitution. It was, in my view, the articulation of judicial review as part of the ratio in the first case which so found that gives the judgment of Chief Justice Marshall its place in legal history. In this lecture, I propose first to place John Marshall and the issues decided in Marbury and Madison within the historical context. I'll then explain how the case was decided, and I'll conclude with a brief examination of a recent example of its contemporary relevance. To put Marshall and the case in their context, it's as well first to remind ourselves of some important events in that period of the history of the United States. Of course, in the world at large, the two superpowers of the time were Great Britain and France. They and their allies had fought the 7 Years' War between 1754 and 1763. The outcome of that war greatly reduced French power in North America and for the time being entrenched the power of Great Britain over its North American colonies, albeit at great financial cost to Great Britain. A relatively brief post-war period in America was characterised by colonial concern as to the nature and manner of Great Britain's exercise of dominion over its colonies. A royal proclamation of 1763 limited settlement to the east of the Appalachians and therefore stymied for a time the hopes of the people who wanted to settle the West. That caused great dissatisfaction. So too did the Stamp Act of 1765, which imposed direct taxes on the colonies for the first time. British insistence on the legitimacy of these and other exercises of power was resisted by many in the colonies. Taxation without representation led to political tensions and soon enough to boycotts and physical confrontations. The so-called Boston Tea Party took place on 16 December 1773. Massachusetts was declared to be in a state of rebellion against the British in February 1775. In April 1775, Paul Revere Road. The shooting started when battles between British military and colonial militia took place at Concord and Lexington, and the American War of Independence began. It didn't end formally until the Treaty of Paris was signed on 3 September 1783. Amongst other things, in that treaty, Great Britain recognised the independence of the 13 colonies comprising the United States. Of course, it was during the War of Independence that the American colonies commenced taking the steps necessary to create the nation of the United States. On 4 July 1776, the colonies unanimously adopted the Declaration of Independence. In 1781, with the ratification of the Articles of Confederation, a new Confederation Congress came into being. It was succeeded by the Congress of the United States, which had been provided for by the United States Constitution, and that was ratified in 1788. So, by 1803, when Marbury and Madison came on for hearing, the new constitutional arrangements had only been in place for some 15 years. Although the new constitution provided for the US Supreme Court when ratified in 1788, it wasn't until the following year, with the Judiciary Act of 1789, that the court was actually established with a Chief Justice and 5 Associate Justices. The first session of the court didn't take place until February 1790. Where did John Marshall fit in with all of this? Well, he was born in 1755 to a prosperous family in Virginia. His father was the American agent of Lord Fairfax, a British nobleman who had very significant landholdings in Virginia. His father was prominent in the community, serving as a Justice of the Peace, a county surveyor, a sheriff, a parish vestryman. Marshall was mostly homeschooled. However, the lack of formality didn't seem to cause him a problem. He and his many siblings, there were 15 in the family, became accomplished and literate through the education that he had at home, supervised by his father and other tutors. He had access to his father's extensive library, and through his father, to the extensive library of his father's employer, Lord Fairfax. It's said that he obtained a copy of Blackstone's Commentaries on the Laws of England and studied them in his teens. At the start of the War of Independence, at age 20, he joined a militia unit in which his father had a command. He saw active service in a battle against the British in that role. He accepted a commission as a lieutenant in the Continental Army, and he spent 4 years at the side of George Washington, ultimately becoming promoted to captain. Washington and Marshall's father were old friends. Washington apparently recognised Marshall's talent and kept him with the headquarters staff, working closely with him. Marshall was with Washington at Valley Forge. For his part, Marshall regarded Washington as a great leader and a personal mentor. Indeed, in the early 1800s, Marshall became Washington's first biographer. In 1779, Marshall was discharged from the army, and he soon determined to embark upon a career in the law. He commenced study at the College of William and Mary in Williamsburg, Virginia, and in 1780, after a pretty short period of study, at age 25, he began his practice as a lawyer in the new state capital of Richmond. Within a few years, he was regarded as one of the leading advocates in Virginia. In the meantime, and in parallel to his burgeoning career as a lawyer, he embarked on a political career. In 1782, at age 27, he was elected to the Virginia House of Delegates, in which he served until 1789. His talent must have been obvious because he was virtually immediately elected by his colleagues in the House to serve on the Council of State, apparently the analogue to the Cabinet. He served in other political roles in Virginia. Politically, he was a member of the Federalist Party, of which I'll address more later. But as such, he was a key spokesman during the Virginia Convention in 1788, which debated ratification of the proposed federal constitution. He was 33. In the late 1780s and the early 1790s, he focused on his legal career and building his personal finances. He continued to develop professionally, and he argued a very famous Supreme Court case called Ware and Hilton in 1796. He was on the losing side, but his argument was well regarded. During President Washington's second term, he was offered national office, but he declined. He nevertheless remained active in politics in Virginia, and he was interested in foreign policy. At that time, as you can imagine, there were still wars going on between France and Great Britain. Washington had steered a course of neutrality for the US. Marshall was outspoken in support of Washington's policy of neutrality. But neutrality for the US and attempting to maintain a trading relationship with both warring parties was not without its problems. By early 1797, the efforts of the French Navy in intercepting US shipping with a view to interfering with US trade with Britain had reached a crisis point. The new president was John Adams, another Federalist. He appointed John Marshall to a three-man diplomatic mission to France to negotiate a settlement of those difficulties and to avoid the threat of war. The French Foreign Minister, Talleyrand, insisted that the US lend France $12 million and that huge bribes be paid to he and other French officials before negotiations would even commence. Marshall refused those demands. The commission was a failure, although it might be said to have paved the way for the settlement between the two countries that eventually happened. However, at home, Marshall's account of what became to be called the XYZ affair, because of the nom de plumes of X, Y and Z used in describing three of the principal actors, the account inflamed public sentiment against the French and made Marshall a hero at home. He was 42. After his return, Washington, former president at the time, persuaded him that it was his patriotic duty to run for Congress, and he did, in 1799, as a Federalist. He even declined an earlier offer of a seat on the Supreme Court by the then President Adams. He became a congressman in 1799, aged 44. Adams nominated Marshall to become Secretary of War, but before that nomination was confirmed, Adams appointed him as Secretary of State. He served in that role until his appointment as Chief Justice, which occurred in the wake of Adams' defeat in the presidential election of 1800. Now, this election looms importantly in the story of Marshall and Madison, of Marbury and Madison. The two opposing candidates in the election of 1800 were, on the one hand, the incumbent President of the United States, Adams, and on the other hand, the incumbent Vice President of the United States, Jefferson. Adams was the leader of the Federalist Party and Jefferson the leader of the Democratic Republican Party. Now, with no doubt great oversimplification, it suffices to say that the Federalists supported the strong national government and friendly relations with Great Britain. They saw in Jefferson and the Democratic Republicans a lack of religious belief and threats to religion, life and property, which are the same threats to those things that had been found in revolutionary France. On the other hand, the Democratic Republicans opposed the centralising forces of the Federalists, avowing that mankind were capable of governing themselves. They favoured states' rights over conferring too much power on the federal government, and they saw in the Federalists the threat of return to quasi-monarchical rule and the subversion of republican liberties. They weren't friends. The election was held from Friday, October 31, 1800 to Wednesday, December 3, 1800. America was a big place. People had to travel by horse. Ultimately, Adams and the Federalists were soundly beaten. But Jefferson, the winner, wasn't sworn in until 4 March 1801. There was a delay because there was a tie between Jefferson and Aaron Burr in the Electoral College, which needed to be resolved before the House. The House endorsed Jefferson as the next president on 17 February 1801. In the meantime, in December 1800, the Chief Justice of the Supreme Court had become ill and he submitted his resignation. So we're now talking about the period between Adams having lost and Jefferson assuming office ultimately on 4 March. During that period, Adams initially offered the job of Supreme Court to John Jay, Chief Justice of the Supreme Court to John Jay. Jay had been the first Chief Justice, but in January 1801 he declined. President Adams offered the job to Marshall. Marshall was 45. With only weeks to go in the Adams administration, Marshall's appointment was confirmed and he took office on 4 February 1801. So remember those dates. 4 February 1801, Marshall takes office as the Chief Justice of the US. 4 March 1801, the new president is sworn in. Bizarrely, to modernise, but perhaps reflecting the relative immaturity of all of the institutions of government at that time, Chief Justice Marshall, sworn in on 4 March, remained as acting Secretary of State for the final month of the Adams administration and to assist in the transfer of power to the incoming Jefferson administration. In fact, as Chief Justice, he administered the oath of office to Jefferson on 4 March, and Jefferson asked Marshall to stay on as acting Secretary of State for a day or two until the successor, the Democratic Republican, could arrive in town. It was while Marshall was acting as Secretary of State in the last days of the Adams administration and before swearing in the new president that Marshall actually had a role in the events which gave rise to the dispute which was determined by his court in 1803 in Marshall and Madison. To understand that and the problem it caused, I have to give you a little more background. Prior to 1801, a structural problem existed within the federal judiciary. The Judiciary Act of 1789 had set up a federal judiciary with 3 tiers. District courts in each state, headed by a federal district judge, 3 circuit courts, staffed by 2 Supreme Court judges and by the district court judge for the relevant district, where the circuit rode, and the Supreme Court. The burden on the Supreme Court judges having to ride circuit and to attend to their own work was significant. And the system resulted in the Supreme Court having to hear appeals from their own decisions when sitting as circuit courts. That created administrative issues. A reform was needed. The reform came, but via highly contentious and overtly political means. Having lost the election in December 1800, a lame duck federal Congress enacted the Judiciary Act of 1801, sometimes known as the Midnight Judges Act. The Act became law on 13 February 1801, less than 3 weeks before Adams' term would expire and the Jefferson administration would commence. The Act expanded the jurisdiction of the lower federal courts, abolished the existing circuit courts, and created 6 new circuit court judges staffed by 16 new federal circuit court judges. It relieved the Supreme Court of the burden of riding circuit. President Adams duly proceeded to fill all 16 of the new positions in the last days of his presidency, and he filled them entirely with Federalists. The appointees became known as the Midnight Judges, so called because the paperwork was, so the story goes, literally being done at midnight on the last day of Adams' administration. One can well imagine the fury of the incoming administration. As part of essentially the same round of last-ditch manoeuvring, and under the auspices of the District of Columbia Act of 1801, which became law on 27 February 1801, President Adams nominated a number of men to the Senate to be appointed as Justices of the Peace of the District of Columbia for 5-year terms. The Senate advised and consented to the appointments on 3 March, remember, 3 March, day before Jefferson's swearing in. Commissions in due form were signed by the President appointing them justices, and the seal of the United States was in due form affixed to the commissions late into the evening on 3 March 1801. However, some of the commissions, including one to a certain William Marbury, were not actually delivered before Jefferson took office on the following day. When the incoming Secretary of State, James Madison, refused to deliver the commissions and recognise their validity, Marbury and some others in the same boat sought a writ of mandamus, and so was born Marbury and Madison. The incoming Jefferson administration reacted swiftly to the Midnight Judges Act. The Judiciary Act 1802 repealed the Judiciary Act 1801. The constitutionality of so doing formed a large part of the debate in Congress. Current Supreme Court Justice Stephen Breyer, writing extrajudicially, has pointed out that the repealing act, the Judiciary Act of 1802, included a provision which postponed the next sitting of the Supreme Court until 1803. And thus we come to Marbury and Madison. The court, at the time of the hearing in February 1803, comprised Chief Justice John Marshall and Associate Justices William Patterson, Samuel Chase, Bushrod Washington, William Cushing and Alfred Moore. Justices Cushing and Moore took no part in the hearing or the determination of the case. That left the court with the bare minimum quorum of 4. The unanimous decision of that 4 was delivered by the Chief Justice. The facts of the case were not entirely clear. The applicants, Marbury and others, having apparently been entirely stonewalled by lack of cooperation from the Jefferson-led executive. Surprise, surprise. Even stonewalled in their attempts to find out whether commissions had actually been formally executed in their names. Ultimately, the facts that I've summarised so far were proved by evidence heard by the Supreme Court. But that gives rise to a particular oddity of the case. The person who affixed the Great Seal of the United States to the disputed commissions on literally the last day of the Adams administration was in fact Chief Justice John Marshall, wearing his hat as acting Secretary of State. If anything further than the affixation of the seal was necessary to make those commissions lawful, for example, delivery of the signed and sealed commissions, then presumably it would have been Marshall's job, his responsibility to make that happen. And the person who had attempted and failed to deliver the commissions and whose affidavit was relied on by the applicants was James Marshall, Chief Justice John Marshall's younger brother. In fact, James Marshall was one of the midnight judges. He'd been nominated by Adams as one of those Federal Circuit Court judges. He was confirmed by the Senate on 3 March 1801 and he received his commission on the same day. The report of Marbury and Madison records his evidence. I won't tarry to read it. Let us pause then to consider what those facts revealed. In a case being argued before the Supreme Court, in which the question concerned whether the court should give a remedy forcing the Democratic Republican Secretary of State to give effect to a wildly controversial statute enacted by the previous Federalist administration, the Chief Justice was in fact a person who had been a prominent member of the very administration which enacted the legislation, including acting as such at the time of the controversy. Moreover, the hearing of the case involved the need for a factual determination as to whether or not commissions had been duly signed and sealed in favour of the applicants. And the Chief Justice, acting as a member of the Federalist administration, was the very person who had affixed the Great Seal to those commissions late in the evening on 3 March 1801, and the person on whose watch delivery had failed to occur. In fact, part of the mode by which that failure had incurred included, on the evidence, conduct of the Chief Justice's own young brother. You see where I'm going. The application of modern standards concerning apparent bias would certainly have led to a successful challenge to the participation of the Chief Justice in the case, or more properly, to his voluntarily recusing himself from the hearing in the first place. Whether it's appropriate to assess his conduct by such standards is unclear. Professor Block, a Georgetown academic, has suggested in a paper that I've read and cited in what I've written, that under the ethical standards at the time, only financial conflicts required recusal. Let's turn back to the facts of the case. The Mr. Lee mentioned in the quote behind me was Charles Lee, a Virginian lawyer who had been the US Attorney General under the Federalist Adams administration, and he was counsel for the applicants. Having ultimately proved the existence of the commissions, his argument sought to establish these three propositions. First, that the Supreme Court had jurisdiction to award mandamus. Second, that mandamus would lie to a Secretary of State in certain circumstances. And third, that mandamus should lie to the Secretary of State, James Madison, in the particular circumstances of the case. Logical, coherent, ordinary way you'd imagine such an argument would develop. As to the first proposition concerning the general jurisdiction of the Supreme Court to award a writ of mandamus, he relied on the Constitution and upon the specific conferral of jurisdiction to award mandamus by the Judiciary Act of 1789, and effectively he also ran an inherent jurisdiction argument. As to the Constitution, Article 3, which should be coming out behind me, provided for the vesting of judicial power and for the judicial power to extend in all cases arising under the Constitution in the Supreme Court. Note in the third paragraph of the quote the distinction between original jurisdiction and appellate jurisdiction. Chief Justice Marshall made much of that. As to the Judiciary Act of 1789, on which Lee also relied, Section 13 was explicit. In fact, it couldn't be more clear. You'll note in the quote behind me that there was, in the last couple of lines, specific conferral on the Supreme Court of jurisdiction to confer writs of mandamus in cases warranted by the principle and usages of law. And as I've said, apart from the Constitution, the Judiciary Act, Lee also developed an argument that the term appellate jurisdiction, as it appeared in Article 3 of the Constitution, should be taken in its largest sense, and it was sufficient to encompass the nature of the court's jurisdiction to supervise inferior tribunals, and therefore should be taken in any event to include the jurisdiction to award mandamus. As will appear, it was on this first limb of his argument that Lee failed, the court ultimately determining that it didn't have jurisdiction to award mandamus because the specific grant of jurisdiction so to do by Section 13 of the Judiciary Act 1789 was void as being contrary to the Constitution. As to Lee's second proposition concerning the circumstances in which mandamus would lie to a Secretary of State, Lee accepted that the writ would not lie to a Secretary of State in all cases, and he drew a distinction between the capacity of the Secretary of State, which was subsequently picked up by Marshall, and I'll refer to that distinction when I get to Marshall's analysis. As to Lee's third proposition, that mandamus would lie to Secretary Madison in the circumstances of the particular case, Lee pointed out that the subject commissions were commissions which appointed their recipients to exercise the judicial power of the United States. And interestingly, he referred specifically to Federalist number 78, which was the one of the Federalist papers in which Hamilton specifically adverted to the doctrine of judicial review. The summary that I've just given of the three propositions that underlied Lee's argument derives from the detailed reporting of the applicant's argument in the report of Marshall and Marbury and Madison. That gives rise to a second curiosity concerning the case. There's no reporting of any argument being presented by the respondent. The reason for that is straightforward. No lawyer representing Secretary Madison appeared before the court in 1803. The case was highly political, well publicised. The failure to appear was no accident. It would have been hard to construe the failure to appear as anything other than an implicit threat by the executive that if they lost, they'd ignore the outcome. Of course, the court still had to do its job, notwithstanding the lack of a contradictor. Marshall's opinion considered Lee's argument in a different structure. He posed three questions for analysis. First, did the applicant have a right to the commission? Second, if he had a right and the right had been violated, did the law afford him a remedy? And third, if the law did afford him a remedy, was it a mandamus issuing from the Supreme Court? On the first question, whether Marbury had a right to the commission, Marshall concluded that once the commission had been signed by the President and had the seal affixed to them by the Secretary of State, he didn't note that it was him, but he said the Secretary of State, the appointments the subject of the commission had been duly made. He concluded that delivery was not necessary for validity. It followed that Marbury and his associates, who are also applicants, were duly appointed as Justices of the Peace for Columbia. The appointment was not revocable, but vested in him legal rights which were protected by law. The Chief Justice concluded that to withhold the commissions was an act deemed by the court not warranted by law, but violative of a vested right. The Chief Justice went on to consider the second point. Did the law afford a remedy to the applicant? Well, the answer to the first point virtually determined the answer to the second point. Marshall cited with approval the statement in Blackstone's commentaries that it's a settled and invariable principle in the laws of England that every right, when withheld, must have a remedy, and every injury its proper redress. He then, the Chief Justice that is, drew an important distinction affecting the circumstances in which executive acts might be justiciable. He essentially adopted the distinction which Lee had drawn between the two capacities in which a Secretary of State might act, and he used that distinction between the circumstances in which, to develop a distinction between circumstances in which executive acts might be justiciable and circumstances in which they could not be justiciable. The distinction that he drew is the progenitor of the so-called political question doctrine in modern American constitutional law. The part of his judgment which drew that distinction appears behind me now. You'll see in that quote the distinction between the two capacities and the identification that in one capacity the acts of the executive are only politically examinable, but where a specific duty is assigned by law, the other capacity, and individual rights depend upon the performance, it's equally clear that the individual who considers himself injured has a right to resort to the laws for remedy. I observe, parenthetically, that that distinction has now developed into a reasonably settled political question doctrine, of which the leading decision is a 1962 decision of Baker and Carr. In any event, having articulated the nascent political question doctrine, the Chief Justice acknowledged that the discretion of the President to nominate to the Senate a judicial officer for appointment, and having done so, to appoint the person nominated, were powers to be exercised according to the President's discretion and unreviewable. But once the President had exercised the discretion and made the appointment, the discretion had been completely exercised and couldn't be reversed. Except in the case of officers removable at the will of the President, the appointee had rights which were protected by law and couldn't be distinguished by executive authority. So, in answer to the second question, Marbury had a right to his commission, and a refusal to deliver it was a violation of his rights, and the law reform afforded that a remedy. You might be thinking, well, where does judicial review come in? Well, the authoritative establishment of the doctrine of judicial review occurred in the course of the answer to the third question, namely, if the law did afford Marbury a remedy, was it a mandamus issuing from the Supreme Court? The Chief Justice posed two further sub-questions, namely, whether the case was an appropriate case for mandamus, and if it was, whether such a writ could issue from the Supreme Court. He answered the first question in favour of the applicants. He acknowledged that the province of the court was not to inquire how the executive performs its duties, whether they have a discretion, but he went on to say that this was a case which concerned vested rights created by an exercise of such discretion that had already happened. It was, the Chief Justice opined, a plain case for a mandamus, either to deliver the commission or a copy of it from the record. The problem for the applicants was that though it was a plain case for mandamus, they were in a court which Marshall subsequently decided couldn't grant that remedy. The Chief Justice went on to address the question of the jurisdiction of the court to issue mandamus. He first acknowledged the only way it would not have jurisdiction was if Section 13 of the Judiciary Act was unconstitutional and therefore incapable of conferring the jurisdiction. He construed Article 3, and you might recall in Article 3 I asked you to note that there was a conferral of original jurisdiction and of appellate jurisdiction. Essentially, he adopted the argument from redundancy. What he said was it can't be presumed that any clause in the Constitution is intended to be without effect, and therefore such a construction is inadmissible unless the words require it. He thought that the Constitution, specifically adverting to two types of jurisdiction, was enough to reject the broad approach to appellate jurisdiction which Lee had invited the court to take. He thought that the issue of a writ of mandamus to the Secretary of State would not be an exercise of appellate jurisdiction, and therefore the Section 13 of the Judiciary Act grant of authority, express as it was not warranted by the Constitution. It was after that the analysis went on to the parts of his judgment for which he's become famous. Having said that the specific section of a statute was not warranted by the Constitution, he next thought it was necessary to inquire whether the jurisdiction so conferred could nevertheless be exercised. He didn't think that was a very hard question, as the quotation behind me demonstrates. The logic of his analysis was as follows. First, the Constitution was a fundamental expression of the will of the people. Second, the Constitution was framed so as to assign to different departments of government their respective powers and to establish certain limits not to be transcended by those departments. It was to define and limit the powers of the legislature and to ensure that those limits might not be mistaken, that the Constitution was written, thought Marshall. And that led to the first passage from his judgment, which I quoted at the outset. The third point he made was that that proposition must be true, because either the Constitution was paramount, giving rise to that conclusion, or it was just an ordinary legislative act, alterable whenever the legislature thought fit. He rejected the latter proposition as contrary to the contemplation of all those who'd framed written constitutions. Fourth, the Chief Justice posed the question whether the courts might somehow be bound to give effect to an act of the legislature which was repugnant to the Constitution and therefore void. And that analysis gave rise to the second of the quotes that I started with. The Chief Justice's point was that if an act of the legislature was opposed to the Constitution, and both the act and the Constitution applied to a particular case, it was the essence of judicial duty to decide which of the two conflicting rules governed the case. It was then an easy step for the fifth step of his argument, which led him to conclude that if the Constitution is to be regarded as superior to an ordinary act, then it must be the Constitution which prevailed when the court had to make a choice between two conflicting rules. Any other doctrine would subvert the foundation of having a written constitution in the first place. And that it would do so would, in his analysis, itself be a sufficient justification for the conclusion that the Constitution must prevail. The Chief Justice thought an additional justification was found in the specific wording of Article 3. The result was that he concluded with the final of the passages that I quoted at the outset. The rule nisi, which had been granted, requiring the Secretary of State to show cause why a writ of mandamus shouldn't issue, was discharged. The technical result, of course, Marbury and the other applicants failed to obtain their remedy. But given the explicit Supreme Court acknowledgement that they had vested legal rights and that mandamus was an appropriate remedy, it being a plain case for mandamus, one might well wonder why they didn't just go down to one of the inferior courts, which plainly did have jurisdiction to issue mandamus, and seek mandamus. Those courts undoubtedly had jurisdiction to grant mandamus. One possibility is, this is 1803, a little over half of the period, the fixed 5-year period is left, and given the relatively small emoluments concerned with the appointment of Justice of the Peace, they might have thought the game wasn't worth the candle anymore. Another possibility is that the applicants, all ardent Federalists, had only ever been concerned with making some political pain for the Jefferson administration and the Democratic Republicans, and were sufficiently happy with what they'd got out of the Supreme Court. There's an enormous literature about this case, both of hagiography and, frankly, demonisation of Marshall and his decision. I'm not going to do a critical analysis of either. But because the orthodoxy inclines towards hagiography, and it's well known, I'm not going to examine that. I thought, however, it might be interesting to touch upon briefly 3 aspects of the case in which it has been criticised. The first and most obvious was the choice of the Chief Justice to participate in the hearing in the first place. Second, there's the Chief Justice's choice of addressing the merits of the question whether Marbury had rights rather than following the more orthodox approach, which was the approach taken by the advocate before him, and consider jurisdiction first. Because if he'd considered jurisdiction first and he'd done it in the way that he actually did it, he would have said, no jurisdiction, it's unnecessary to go on and consider anything else. Critics of Marshall suggest that his choice to embark upon a consideration of merits before considering jurisdiction was informed by his own strong federalist politics, and it could even have been influenced by his own concern not to have his conduct criticised. That read of the decision turns on the proposition that his conclusion that the commissions were valid upon the seal being affixed and that they didn't need to be delivered to be valid might have been influenced by the fact of his own involvement in their failure to be delivered. It seems to me that line of criticism is a bit speculative. Certainly, it's one that Marshall opened himself up to by choosing to participate in the hearing. Supreme Court Justice Breyer, in the book to which I've earlier referred, defends the decision of Marshall to consider both jurisdiction and merits. Essentially, he says that there were 2 methodological propositions in play. First, he accepted that one of such methodological proposition is that where a court lacks jurisdiction, it shouldn't decide on merits. But he said another methodological proposition is that a court should try to avoid making constitutional decisions by deciding non-constitutional matters first. In other words, a court oughtn't decide constitutional matters unless it had to. Breyer suggests that in the circumstances before him, Marshall would have found it difficult to show that he had to decide the constitutional question without embarking on the analysis that he did embark upon to show that there were legal rights which would be given a remedy unless the constitutional issue was decided in a particular way. The final group of criticisms are to the merits of the theory of judicial review itself, namely that legislation contrary to the Constitution is void and the court's the appropriate body to determine that. Sackville's paper, to which I've earlier referred, identifies 2 central criticisms here. First, that Marshall assumes rather than demonstrates that the proper construction of the Constitution was that courts should exclusively have the jurisdiction to decide the limits of constitutional power. Second, that the principal philosophical problem with the Marshall theory of judicial review is its counter-majoritarian character, in that by declaring a legislative act invalid, the court thwarts the will of the current group of the people. It seems to me that latter line of criticism involves normative rather than legal considerations. If Marshall's construction of the Constitution is correct, then it's not Marshall's theory of judicial review which is counter-majoritarian, it's the Constitution itself. Any normative discussion is, to my mind, properly directed at the Constitution and whether there might be a better way of doing things. There's a lot of literature on that. I'm not going to tarry on it. That brings us to the question whether there was a gap in Marshall's reasoning to justify his conclusions about what the Constitution called for. Certainly his reasoning was brief and it was propositionally framed, but I think it was logically complete. His starting point was that by the adoption of a written constitution, the American people had intentionally rejected the notion of untrammelled executive and legislative power. And they'd sought to impose legal limits designed to be permanent and not capable of being altered by the ordinary acts of government. Now, that assumption seems to me to be the proper construction of the Constitution. I do agree that it is assumed rather than demonstrated, but I've not read any persuasive argument against its correctness. Once that basal assumption is accepted, then one asks oneself, who decides whether one of the departments of government has sought to go beyond its limits? It couldn't be the legislature or the executive who decided, because that would contradict the basal assumption. In my view, giving effect to the basal assumption drives one firmly towards making the decision that it must be the judiciary who so determines it. Let me conclude, you'll be relieved to know, with just a brief examination of its contemporary relevance. The decision is no mere relic of legal history. We know the doctrine is alive and well in the US and indeed in Australia. My focus presently is on justices of the Supreme Court, so let's stick with the US. The most famous recent examples of the contemporary relevance of Marbury and Madison concern the litigation which has arisen consequent upon executive orders issued by President Trump, which are said to be unconstitutionally directed towards Muslim immigrants. There have been two subsequent cases to the decision I'm going to address, but they haven't yet been determined. So, as the final task, let me briefly take you to the decision of the Ninth Circuit Court of Appeal and demonstrate its debt to Marbury and Madison. It's Washington and Trump, decided this year. You'll recall there was an executive order suspending admissions and entry of aliens from Iraq, Iran, Libya, Somalia, Sudan, Syria and Yemen. Washington and Minnesota challenged the executive order as unconstitutional, and the matter came before the court. They obtained a temporary injunction, and the matter came before the Ninth Circuit Court of Appeal on an application by the government for a stay pending an appeal. The court denied that motion, concluding, amongst other things, that the government hadn't shown a sufficient likelihood of success on the prospects of the appeal. Only one part of the appeal is relevant for present purposes. The government had contended that the court below had lacked authority to enjoin enforcement of the executive order because of a contention that President Trump had unreviewable authority to suspend the admission of any class of aliens. But they didn't have any sophisticated analysis of the political question doctrine. The court observed that the government had taken the position that the decisions were unreviewable, even, you'll see in the quote behind me, if those actions potentially contravene constitutional rights and protections. The court rejected such an extravagant proposition in no uncertain terms. The central part of the rejection is contained in the quote that now appears behind me. You'll see the contention in the first line that the unreviewability runs contrary to the fundamental structure of constitutional democracy, and the citation of Boumediene and Bush, and then the statement that within our system it's the role of the judiciary to interpret the law, obviously harking back to Marbury and Madison. And you'll see the citation of the other cases. Now, although there's no express citation of Marbury and Madison, the passage from the majority judgment in Boumediene and Bush was in these terms. You see in the quote the reference to holding the political branches have the power to switch the Constitution on or off at will, and you'll see in the final sentence express reference to Marbury and Madison. The truth, ladies and gentlemen, is that the tension between those who seek to exercise executive and legislative power and those in whom reposes the function of determining and enforcing the constitutional limits on that exercise will always be ongoing in a vibrant constitutional democracy. And when the former become more, shall we say, adventurous than normal, that tension can become quite elevated, as the continuing clashes between the Trump administration and the judiciary demonstrate. Power does not enjoy being thwarted. I won't speculate on the way in which those cases will eventually be resolved by the Supreme Court, save to say one thing. I'd be very surprised if the Court accepted the extravagant proposition that the subject executive action was unreviewable, even if it contravened constitutional rights and protections. The constitutional principle established by Chief Justice John Marshall in Marbury and Madison would be an insurmountable obstacle to that proposition.
For any decision to survive the tender attention of the United States Supreme Court for more than a few decades is unusual. For a case to still remain authoritative, as Marbury and Madison is, in its third century is exceptional. Justice Bond has provided us with intriguing insights into both Marshall's mind and the politics which gave birth to that famous decision. And all of that remains relevant. Marshall's appointment as Chief Justice during John Adams' lame duck period was frequently cited in the United States Senate when that body declined to consider President Obama's recommendation of Merrick Garland to the Supreme Court. Tonight's lecture brilliantly brought to life the machinations which surrounded Marshall's appointment and his decision which confirmed the Supreme Court's power. Would you please join me in thanking Justice Bond again? May I make one small, short advertisement? The second of these lectures in the Selden series will take place in this court on the 22nd of June, a Thursday. It concerns a case that many have heard of but few have read, Mackenzie and Mackenzie, 1971 Probate 33. Its importance is that it is the origin of the term Mackenzie friend, and indeed we have the Mackenzie friend to present the paper that night. He was the first and he maintains the best Mackenzie friend. Thank you very much for attending. Please join us for refreshments in the gallery.